Okay, so how do we begin to think about making plans for kind of managing these risks, for deciding how and to what extent we're going to prevent things, what can be prevented, deciding how and to what extent we're going to respond? We have to engage in some kind of evaluation of the scope and the likelihood of a risk that might be occurring. And one way that we might think about doing this is in terms of putting some kind of valuation on the assets that are at risk, an identification of the threats to those assets, an assessment of the vulnerabilities that those assets are subject to, and that assessment includes figuring out what the probability or likelihood of loss is. Of course, we're rarely going to be able to precisely calculate the probability of a loss, but at least in some way, in some meaningful way, try to do that. And then you conduct what's called a gap analysis. Now, gap analysis sounds like one of those great business buzzwords, which it is. And again, it's a business buzzword that is really just common sense. What is a gap analysis? We're just looking at the difference between the level of risk, given the value of the assets, the identification of the threat, the likelihood of loss. That's our level of risk, and the level of protection. And what's the gap between those? Now, if there's no gap, well, then we have sort of the optimal level of protection. If there is a gap, then we don't have the optimal level of protection, and we have to decide whether we need to invest in more protection. Now, you all, as law students, some of you, maybe have worked in business or have had some experience in as a business major or in business school, and you're familiar with some of these. Maybe some of you aren't directly familiar with some of these ideas, but you all, having gone through the first year of law school and have taken torts, are familiar with this, because there is a classic example of how this works in the law of torts, which is the hand balancing test. And I'm sure you all remember this and savor the time that you learned this in torts. I always, when I teach torts, enjoy teaching this. So B, of course, is the burden of taking precautions. And on the other side, P is the probability of loss, and L is the scope of the loss. So you multiply the probability of loss times the scope of loss, and you decide whether that figure is greater or less than the burden of taking precautions. And if you decide that P times L is greater than the burden of taking precautions, then that suggests that there's a duty to take some precautions, right? If the burden is greater, that suggests that there's not a duty to take precautions. Now, as you recall from reading through tort cases that try to apply this formula, this is not an exact formula. Nobody, no judge in a tort case is literally having an actuary, plug in numbers into this formula. It's a rough and ready kind of measure of, risk management. Now, another thing that you ought to remember from torts and from looking at the hand balancing test is that risk management is always tied to the question of legal liability, because if you're not taking adequate precautions, then you may well be liable, for example, in negligence, and that the uncertainty always leads to the question of insurance. When we use the hand balancing formula, what are we really asking? We're really asking who has the responsibility to insure against the risk of loss. So, if the burden for the defendant, the allegedly negligent party, is lower than PL, which is really the cost to society, the cost to the injured person, then we say, well, then the potentially negligent party has the duty to insure, and that includes taking steps to mitigate the risk and enacting, spending some money to enact precautions, and literally purchasing liability insurance often, so that if the risk is realized, there's some way of compensating. Alternatively, if the burden is higher, we might say, well, it's really not that actor's responsibility, it's society's responsibility to ensure, to bear the risk of loss. So the individual who might be injured, you might have to decide, do I want to engage in this activity, or if I do, I'm putting myself at some risk, or we might have a system of health insurance or other things like that. Obviously, those discussions get sort of very complex, and again, this is a rough measure of thinking about this. But what I do want you to know is all of these things that we're thinking about, particularly for us as lawyers, we ought to be thinking in terms of, well, all right, I'm managing risk within the background of facing some liability, and I want to think about how am I counseling my organization to ensure, whether it's precautions they have to take, whether it's literally looking into insurance markets. And as we've alluded to a couple of times, I think during this semester, there are developing insurance markets specifically for cyber risk insurance. Those markets are relatively young still, relatively untested still, but it's something you guys out there in practice dealing with these issues are going to be thinking about.